Our focus question is following. How has the international legal framework addressing violence against women evolved over time, particularly from CEDAW to the Istanbul Convention, and what are the broader implications of these changes for approaches to combating gender-based violence? So, Silvana, do you want to start?
Thank you. Thank you very much. I'm really happy to be here sharing this panel, and I want to send a big thank you to the organizers for the kind invitation. So today I'm going to be speaking to chapter 3 of my book published in 2022. The book is entitled Feminism, Violence Against Women and Law Reform, The Colonial Lessons from Ecuador. And the chapter that I'm going to be speaking to is called Violence Against Women, Human Rights and the Turn to Criminal Law. And I am going to be focusing, although the question is indeed addressing the Istanbul Convention, I am going to focus a little bit more on the inter-American system of human rights, and because I think its role is really important in current dominant framings of violence against women, and in particular, the Belém do Pará Convention is very influential in the region. So I'm basically going to make 3 points during this presentation. The first one is that even as addressing violence against women utilizing the criminal legal system may seem very obvious right now, to us, this was not always the case. This obviousness was not always dominant. And so I'm going to, in a way, simplify the chapter that I'm presenting by dividing the international approach to violence against women in a pre-penal period and then the turn to criminal law. So that is a first point to make. What is now obvious wasn't always so obvious. Feminist movements and also international bodies used to address violence against women more as a concern that required, yes, a state response, but rather in the form of public services very often, rather than in the form of law reform or activating the penal apparatus. I will also make the point that human rights as a discourse, the dominant liberal international human rights discourse, is key in, it's correlated with the emergence of these first framings of violence against women as an issue where law reform and criminal law are advised as the state response by international human rights bodies or international bodies in general. And my third and final point is an invitation to interrogate the term carceral feminism, because I also want to argue that both at the international, regional, and local levels, non-feminist actors that have an influence in law reform are key in the way in which we currently understand violence against women, and it is important to address in detail the historical transformations that will show us how there are other discourses also contributing to this penal framing of violence against women, including family protection, and in the case of post-colonial Latin America, the colonial legacies regarding women's roles in the household, women's roles in relation to nation building, and so on. So I think I will begin with a document that is the report of the World Conference of the United Nations Decade for Women, Copenhagen 1980, which is one of the first documents that I have been able to identify addressing violence against women, in particular domestic violence, as an issue in a UN public document, where you find the expression battered women mostly, which is depicted as a problem of serious social consequences, and the recommendations have to do with assistance, shelters, rehabilitation, childcare, employment, healthcare, and housing. So as we see, this is 1980, very different language than the one the UN currently uses for the most part. And in the field of gender and development, this is a moment when you start seeing violence against women mentioned as an obstacle for development, but not necessarily referring to policing or criminal or activating the criminal legal system as a effective response. And then at the regional level, and I'm going to use the case of Ecuador, which is the subject of the book I mentioned, to illustrate that at this point, you do find emerging women's movements. Some of them call themselves feminists, others do not. So for example, in Ecuador, you find indigenous women's movements who are more focused on denouncing the state violence, for example, through military occupation of their territories, rather than in appealing to law reform as an instrument for social change. You have the Marxist left, which very early on in Ecuador has a counter-carceral stance, we could say, when they reject the imprisonment of women and demand a different approach to women's criminality, the Communist Party in Ecuador, for example. And then when you look at what we could call the more mainstream women's movement in this pre-penal period, their engagement with criminal law has to do with advancing the elimination of laws and provisions, of criminal laws and provisions that are considered discriminatory, that are considered violent against women as such. So for example, in Latin America, you find that adultery was considered a criminal offense when committed by women, or you find that the killing of women was excused if they were, as the penal codes of the time used to say, if they were caught committing illegitimate carnal acts, for example, right? So then killing the woman and her accomplice, quote unquote, was not considered a criminal offense in the case of Ecuador. And if the person who caught them in the act, so to speak, was the husband of the woman, then he wouldn't be criminally liable. And this was actually enforced until 2005 in Ecuador. But this was the focus of the early movements, engagements with criminal law. And the CEDAW, as you know, in 1988 did not really address violence against women explicitly. It is later on with an addendum, so to speak, that violence against women comes to be framed as a form of discrimination against women. So this is just to describe, again, what we could call a pre-penal period. But then in the 1990s, we start seeing some more technical disciplines become interested in violence against women. You have public health, and you have, international bodies that are concerned with public health starting to speak about violence against women as a threat to public health. We have, again, the international development concerns. So more kind of technical and scientific framing start to be used. And this is also a time when violence against women starts to be spoken about as a violation of human rights. And this, to a large extent, is due to the work of non-governmental organizations that acquired a consultative status at the UN, for example. And the motto, women's rights are human rights, starts to become more and more prominent until finally in 1993 in the Vienna Conference on Human Rights, it is established officially that women's rights are human rights. And I am pointing this out because it is more or less at this point when we start seeing the first international instruments that require states to respond through law reform and through criminalization to emerge. But I want to point a very interesting document, which is a report that appeared in 1985, a report from the 7th UN Congress on the Prevention of Crime and Treatment of Offenders, which is the earliest document I have been able to locate, which recommends states criminalize violence against women. And it uses the argument of the symbolic power of criminal law. And then again, in the Vienna Conference in 1993, we also have this appeal to the symbolic power of criminal law. Violence against women is established as a violation of human rights, and it is stressed that legislation is really key to achieve the elimination of violence against women, that naming violence against women as a crime and therefore penalizing it is what is going to communicate that violence against women is unacceptable. And now I'm going to turn a little bit to the regional level and the Organization of American States and the Inter-American Human Rights System. So in 1994, we have the subscription of the Belém do Pará Convention, which is the first international instrument that addresses violence against women in particular, like exclusively. And it was, this treaty came to fruition through the work of the Inter-American Commission of Women, which is considered in many ways the mother of the UN women of today. And this is the commission that identifies a gap in the fact that violence against women was for the most part not criminalized as a specific separate criminal offense, aside from ordinary penal code's criminalization of injuries or physical violence and so on. And indeed, the Belém do Pará Convention was ratified by all of the states that are part of the Inter-American system, except for the United States and Canada. So it's basically a Latin American and Caribbean Convention on violence against women. And this unleashes a kind of wave of laws on violence against women across the subcontinent during the 1990s. Some are specialized laws, others are specialized provisions within larger legal bodies, but we see this coming, emerging almost at the same time in the entire region in Latin America. And we also see specialized police commissariats and specialized courts for violence against women a bit later on. And I'm going to finish by mentioning how the first law on violence against women, specialized law, came to be in Ecuador. And of course, the fact that Ecuador ratified the Belém do Pará Convention was used as a strong argument by women's movements to promote the creation of a specialized law on violence against women. But what I wasn't expecting when I was looking at parliamentary debates of the time, this is the 1995 when this law emerged, when this law was passed in Ecuador, that it wasn't really women's movements that were the main contributors to the framing of violence against women as a criminal offense. It was rather the non-feminist lawmakers, the non-feminist actors of the National Congress of Ecuador that for the most part suggested that the already existing penal provisions on violence in general should be in many ways copied and utilized on violence against women, as opposed to creating a new approach, which is what the women's movements wanted. And of course, I'm not saying that the women's movements were opposed to criminalization. They indeed considered that this law, which was partly criminal, partly civil law, was the first big achievement of the women's movement in Ecuador. But I want to stress that one of the main rationales exposed by the lawmakers of the time, who were the ones who passed this law, one of the great arguments was protecting the family and protecting children from violence. And this rationale of family protection has been present. If we look even at colonial documents and very early Republican documents across the region, we will see that there were legal provisions in place to protect women and children from patriarchal violence, in a way trying to establish a non-violent patriarchy without really interpolating the gender roles of men, women, and children in this Eurocentric kind of family model that is considered the ideal to where nations, the newer Latin American nations, have to walk to. So I'll end there by just saying that nuancing the term carceral feminism, then it's important so that we don't lose focus, so that we don't shift our attention away from the role that many state and non-state, non-feminist actors have had and still have in reproducing a criminal law-centric approach to violence against women. Thanks a lot.
Thank you, Silvana, for your insightful presentation. It was really interesting, well delivered, and thought provoking. Thank you a lot. And now we will move on to SM. Floor is yours, please.
Good evening, everyone. So I decided I decided to kind of focus this talk on one particular angle that I think just irks me and increasingly irks me with the current politics, and we'll see why. We'll just get it. So this presentation actually examines the limitations and possibilities of international legal frameworks addressing gender-based violence. And rather than tracing a linear evolution from CEDAW to the Istanbul Convention, it asks more foundational questions. So whose experiences of violence are legible within these frameworks? What assumptions about gender, victimhood, and harm underpin their protections, and how might these frameworks perpetuate the very systems of violence that they claim to challenge? So by critically engaging with the conflation of gender, of gender with women, the exclusion of other people marginalized by gender, and the erasure of economic and structural violence, this talk interrogates the coloniality of rights discourse and practices. And it contends that while we must have frameworks to address violence, these conventions still fail to address systemic and epistemic violence and increase a reliance on punitive carceral solutions that ultimately limit their transformative potential. So in response, I propose reimagining rights as a tool for redistributing care, addressing global inequalities, and building pathways to collective liberation. And so the international legal framework addressing violence against women has changed significantly over time in ways that I think probably most people in this audience are familiar with, if not more familiar with than even I am. And CEDAW serves as an early cornerstone. But CEDAW, while it focuses on eradicating discrimination against women in law and practice, promoting equality by addressing systemic barriers, its emphasis on women as a protected category presumes a universalized subject that erases differences, often centering cis, heterosexual, and white womanhood as the implicit norm. I'm going to put in brackets there, like a proximity to whiteness being kind of implied in regions in which that might not make sense. This framing reduces complex systems of harm to a singular narrative of victimization while marginalizing those whose experiences actually deviate from this archetype. The Istanbul Convention, I'm interested in this talk, as it marked a shift and kind of broadened this scope to think through domestic violence and embrace what's called a victim-centered approach. And while this move acknowledges the multiplicity of harms and highlights the needs of survivors, it also reinforces carceral logics deeply embedded in the colonial spirit by allowing the carceral and punitive and sometimes vindictive desires that often arise in the immediate aftermath of violence victimization. And so that framing of victim becomes a fixed category tied to exclusionary imaginaries that obscure how those labels as perpetrators always emerge from histories of violence victimizations themselves. For example, structural violence, colonial dispossession, economic precarity, and racialized subjugation remain unexamined within this framework, even though such conditions shape cycles of harm. And as another example, interpersonal violence enacted on those rarely recognized as survivors, so cis men, for example, men of color, remains unimportant to these frameworks, although surviving violence is intimately tied to the forms of violence that we as people enact. So altogether, the fixation on the victim means that rights frameworks actually lose redressive capabilities. By narrowly focusing on individualized violence, the Istanbul Convention not only leaves systemic and structural violence unaddressed, but also prioritizes punitive interventions. So these interventions designed to protect the victim risk perpetuating harm by sidelining transformative and restorative possibilities. Abolitionist approaches recognize that focusing solely on punishment often fortifies the same systems of carceral control that enable violence through an all-consuming desire to correct contextually defined intolerable behaviors. Furthermore, the exclusion of broader histories of victimhood, those experienced by individuals who are labeled in that moment as a harm doer, as a perpetrator, forecloses pathways to accountability that actually center healing or transformation. And so, in this sense, while the Istanbul Convention adopts a progressive tone in expanding protections, its reliance on carceral mechanisms ultimately limits its capacity for transformative justice and rights, if we understand rights as safety, dignity, longevity for most humans. This reliance reflects a colonial logic, a failure to address the root causes of harm embedded within global structures of inequality that produce everyone's histories as always harmed and harm doer. Without disrupting these structures, the frameworks designed to combat violence risk reinforcing the very systems that perpetuate it. So a critical limitation of international legal frameworks addressing violence against women is their persistent conflation of gender with woman. This conflation reduces gender to an exclusionary category that centers the cisgender heterosexual woman as the archetypal victim of violence. And in doing so, these frameworks construct an imaginary of a protected personhood wherein the subject deserving of rights is legible only through proximity to a normative cis femininity. This exclusionary logic is starkly visible in the current anti-trans moral panic here in the UK, where white cis women, politically raised within this paradigm that frames them as the quintessential victims, are actively campaigning to roll back the rights or protections of trans women. And their efforts are underpinned by an inability to break free of the bioessentialist binary that equates, quote, born with a penis with harm doer and born with a vagina with victim. This analytical binarism not only renders the violence enacted by cis women against trans women illegible, but also distorts the categories of victim and perpetrator as outlined in frameworks such as the Istanbul Convention. For example, despite showing evidence showing that trans women are disproportionately subjected to physical, material, epistemic, and psychological violence, this harm is systematically excluded from mainstream narratives of gendered violence. The rigid construction of white cis women as inherently vulnerable means that even when they enact violence, such actions are rarely interpreted through the criminalized lens of perpetration. Instead, the protections outlined such, in the Istanbul Convention, for example, such as prosecuting perpetrators and protecting victims, are selectively applied in ways that maintain cisnormative and racial hierarchies. This dynamic becomes even more glaring when one considers the contradictions within the anti-trans movement. So, cis women who insist on self-determination over how they are named, right, rejecting terms such as TERF or transphobic woman or even cis woman itself, right, simultaneously advocate for imposing labels such as man or male, as well as invasive tests and strictures to police cis women of color, demanding they prove their status as women born with vagina and all the normal accoutrements in order to compete in sport. Such actions expose how women's rights, as currently interpreted in this context, operate not only to exclude and delegitimize other people's movements to live safe and dignified lives, but also to reproduce colonial and racialized systems of surveillance, control, and segregation. Notably, their efforts to retain lower athletic prowess by determining women's quote-unquote natural hormonal levels only serves to concretize the same imagination of a natural disadvantage or weakness that allows them to their perpetually vulnerable status as white women. This analytical binarism and the selective legibility of violence work together to obscure systemic harms and maintain the exclusionary framing of gender within human rights frameworks. As Sylvia Wynter's critique of the human illuminates, these frameworks reinscribe colonial logics by upholding a normative, Eurocentric political and material subject, a genre of man, from which racialized people are debarred. In this moment, the anti-trans moral panic demonstrates how these frameworks enable violence to be invisibilized when enacted by those considered inherently victims. Without disrupting this paradigm, the frameworks fail to address the broader systems of harm they purport to combat. To add an additional example to highlight the failings of analytical binarism is that racialized men are also marginalized by gender. As Kathy Cohen argues, a queer analytic enables us to see. So a queer anti-carceral lens could highlight, for example, how the racist margins of employability, the politics of segregation, and the material violences that exclude Black men from the public or from manhood writ large actually ushers them into spaces of continuous sexual abuse, like the prison, that systematize sexual violence as cavity searches, forced nudity, or social domination through rape encouraged by corrections officers. So how does a violence against women agenda or a gender-based violence framework regard the rights or protections of Black, or even in this, to use that same example, Palestinian men, right? Certainly not as victims of gender-based violence. So while international legal frameworks addressing gender-based violence have evolved to incorporate broader protections, they remain fundamentally limited by their narrow conceptualizations of gender and violence. By focusing on interpersonal harm, these frameworks often fail to name and address the structural and economic violences that underlie gendered harm. This oversight is particularly glaring in the context of global inequalities perpetuated by Euro-American profiteering, which relies on the extraction of resources, labor, and stability from recently colonized regions. These systemic violences disproportionately harm individuals in marginalized and racialized communities, compounding vulnerabilities that transcend the bounds of gender as narrowly defined by current frameworks. For example, the economic precarity imposed by exploitative global supply chains exacerbates gender violence by entrenching power imbalances and limiting basic access to basic needs. Yet this structural harm is rendered invisible within the framework's focus on prosecuting perpetrators and protecting victims. Moreover, the failure to name these agents of economic harm, the corporations, the states, and the systems that drive exploitation, reflects the colonial underpinnings of human rights discourses. So to go back to Sylvia Wynter and her critique of the human, that notion of the human itself is a colonial construct, one that these frameworks continue to uphold by limiting their analysis to interpersonal violence. This reinforces the exclusionary politics of rights, failing to account for the systemic conditions that produce cycles of harm. A transformative approach to gender-based violence would demand a reimagining of rights as a tool for addressing the global redistribution of care and resources. Such a framework would shift the responsibility for ensuring livable lives onto the global systems and states that perpetuate harm. It would also require recognizing that care, currently flowing from the global south to the global north, and I'm someone who argues that there are many souths within that, so we can talk about that if you'd like to in the Q&A. But flowing in this direction, in the form of labor, resources, and wealth, must be radically reoriented in reverse to support those most impacted by structural violence. Without such a redistribution, rights remain entangled in necropolitics, frameworks that claim to protect life while perpetuating conditions of death and precarity for those outside their narrow conception of personhood. True emancipation from gendered violence, therefore, cannot rely on punitive mechanisms or limited protections, but must engage with root causes of harm. This requires challenging the colonial logics embedded within these frameworks and envisioning a world where care, dignity, and safety are accessible to all, regardless of the colonial boundaries of victimhood, the narrow imagination of violence, and the growingly contested borders of gender.
Thank you a lot, Sam, for sharing such a thoughtful presentation, and it was true and light. Thank you a lot. I think now we are ready to move our question, but before I ask it, I just will remind to everyone that you have a chance to put your question in the chat. If you want to ask something, it now, and later when Sandra will allow you to raise your hand, just raise your hand and ask if you want to ask, not type. So our question is now, I will ask it, and each speaker will have a couple of minutes to respond. I will ask you to give concise replies to our question because of time. So the question is, how can we incorporate anti-colonial and anti-carceral perspectives into human rights and gender law reform? And what are the implications for conceptualizing rights as an emancipatory tool? So, Silvana, do you want to start? Maybe?
Yes, sure. Thanks a lot. And thank you, Sam, for your wonderful presentation. I really enjoyed it. So now I'm going to move a bit to what's been my most recent work, which has been empirical research with anti-carceral grassroots movements in Ecuador. And what has emerged from this research, first, is that people see at this level, which is for the most part working class, informalized workers who are part of this grassroots anti-carceral organization, they see there is an incompatibility between their perspectives, which they recognize as anti-racist, and they recognize as one that values, as Sam mentioned, care work and reproductive labor. There is an incompatibility between that perspective, that anti-colonial feminist perspective, and liberal human rights. And this is very fundamental. It's at a very fundamental level. So perhaps it is important to know, recognize, and come to terms with the fact that law reform in the arena of international dominant legal frameworks may not be what people want at the ground level, at the grassroots level, or what they need indeed, what they prioritize. So, however, if we do want to think about mechanisms that could strategically, as we work toward a more radical dismantling of liberal legal systems, if we want to think about strategies that can advance our goals while we play in the enemy's court, so to speak, I would think that some of these strategies involve decriminalization, so focusing our efforts more on what can be not anymore considered a criminal offense, as opposed to continuing to expand the catalog of criminal offenses, and indeed decarceration, so looking for different ways in which we can open the gates of the prison and depopulate prisons. So, for example, Mujeres de Frente, which means women on front or women leading the way in Ecuador, is a collective that advocates for the decarceration of all women in women's prisons, considering that in Ecuador, as in many other regions of the world, people who inhabit women's prisons, for the most part, have committed nonviolent crimes. So they use that sort of quantitative information to advocate for the idea of full decarceration. I also think, I really agree with the fact that we need a new theory that connects the impact of penal violence, the violence that is connected to the criminal legal system, its impact on social reproduction, on the depletion of care work, on the exploitation of low-paid and unpaid reproductive labor. And this is probably, maybe we're not going to arrive to the idea of rights if we continue advancing this approach, because as we currently understand rights, it is the state that grants rights. It is in many ways a state-centric approach. After all, international courts and international bodies demand things from states in order for this justice paradigm to work. And in many ways, this displaces communities, people who know each other very well, organizers who understand how violence works within their communities, and deprives them of tools, of material resources that could be actually put to work toward meaningful protection from violence through safe spaces, like physical safe spaces, which in the case of Ecuador are lacking very evidently. And also the possibility of communities to have access to collective resources that they can redistribute in a way that reflects their deep understanding of their context, right? So I think that community justice is typically displaced by this focus on the state, on state law, on state interventions, which doesn't mean that I do not believe that there should be something akin to the social state, right? A mechanism to definitely redistribute resources and care, as Sam very brilliantly explained. So the last thing that I want to say is one of the main challenges that I suppose all of us encounter, and everyone who, or many of us who are trying to work through an abolitionist lens encounter, is how unfriendly what we could call the general public is to the idea of criminals having rights. I have encountered this a lot in my grounded work, like collectives say, state agencies, but also NGOs do not really like to hear us speaking about a non-carceral form of justice because it is equated to impunity. So I think that this is something that we need to continue addressing, even as we feel that we repeat ourselves a lot when we explain that an abolitionist or anti-carceral stance does not equate favoring non-accountability. So this is something that still needs to be addressed so that we can smooth out a little bit the pathway toward a different approach to justice. Yeah.
Thank you a lot for your response. Sam, do you want to give an answer to our question? But please try to be concise.
Yeah, no, part of me wonders why bother, Thank you, Silvana. That was really beautiful. In the effort to be concise, I think I'll just highlight a couple of action points, and some of which I think really overlay with Silvana's quite well, so I won't get into. My thoughts are decriminalize and decarcerate. And, one part with the decarceration, I think, especially as I develop kind of my thoughts on the colonial carceral as a framework, is to recognize that decarcerate isn't just about kind of how we take people out of prisons necessarily, right? But also how we think about borders, how we think about detention, how we think about corrections as they play out in our lives and in our kind of our interactions, which include even the home. I think for anti-colonial perspectives, I really do want to stress the kind of resisting the epistemic violence and trying to strengthen our kind of frameworks to uncover the subjugated knowledges that are, have been subjected to epistemicide, and uplift those in order to create the solidaristic imaginaries that can help us build action infrastructures that actually lead toward something. And it might not be rights. It might be rights in a relational kind of sense, in a communal sense, rather than in the statist way, but maybe move beyond rights as endpoints, and building towards, how do we uplift each other's goals of living, right?
Thank you a lot. Your presentations were really wonderful, and your responses very insightful. We will now transition to our